It was about an hour into their deliberations, the jury alerting the judge that one of the jurors is having trouble following the judge's instruction on the law. The foreperson requested that the judge actually talk to the juror, but instead, the judge said the jury should continue deliberating and suggested that he might offer firmer instructions if the issue with that juror continues.
Eyewitness News reporter Darla Miles has been following this all day long and the days of development. She's live in Lower Manhattan with the very latest on the deliberations. Darla.
Liz and Mike, when I was inside of the courtroom and this note was read out loud, it seemed like there was a panic inside of the courtroom on exactly how to respond to this jury note. And the way the note was read out loud, it seemed like jurors were a little bit frustrated with juror number 25, the one who they are concerned about. But we already knew this 5-count indictment was going to be a challenge to deliberate, but no one guessed there would be issues with the jury this soon. The first day of deliberations at the Sean Diddy Combs racketeering and sex trafficking trial sent into a tailspin just an hour and 10 minutes in. Deliberations beginning at 11:19 after a 2-hour reading of jury instructions. All 12 jurors and 5 alternates with their eyes laser focused on the printout, seeing following back and forth on the page line by line. The first note coming back quickly, which is not uncommon at all, saying, "We have elected juror number 5 as our foreperson." Then a second note after lunch saying, "We are concerned juror 25 cannot follow your honor's instructions. Can you please come out and speak with him?" Before Judge Arun Subramanian read the note to the court, it was clear something unusual was going on. Defense attorneys, having seen the note before it was read out loud, seen huddling around Combs, and the battle lines were drawn about how to respond. The parties finally coming to an agreement, that taking almost an hour, and the court sending back a note to an already contentious jury, reminding them to follow his instruction to follow the law. Combs' 3 adult sons and teen daughters in court today, as well as other relatives, and his 84-year-old mother, who has attended almost every day of the trial. The family, all standing by, anxiously awaiting the verdict. Now, one of the most powerful moments of the day was a time when they cleared the courtroom. We were all asked to leave, but the closed circuit cameras were still on. And that is when we saw Sean Combs standing in the well and 2 rows of his family members. They were all holding hands. They had their head down. It appears as if the family stopped for a moment of prayer as the jury began its deliberations. Reporting live in Lower Manhattan.
That's fruit. Anyway, you know what amazes me about what I just heard? As frequently as this situation develops during a complicated trial, I am just astonished that there's nobody in these mainstream media providers that is aware of that and how ignorant that makes their system look. This is not uncommon, and it's not even a big deal. It comes up where juries have questions, and the stock answer is some versions of the ladies and gentlemen of the jury, the court directs you to refer to the written instructions that are in your trial jacket and continue your deliberations and reach your verdict as truth and justice may dictate. So if you can do so without violence to your individual opinions, get on back and go do it. This also illustrates something that I have complained about often. Practice of law has become so commercialized that there are too many people doing it, and the people that do it, even though they are supposed to nominally be great trial lawyers or prosecutors or judges, they are very inexperienced. And 2 hours of instruction on this just belays what's going on. Remember me talking about it's just 5 counts in an indictment, and it went on for 14 pages in an hour-long initial press conference that the U.S. attorney in New York had. This is extraordinary, and it shows me that there's something else going on. Now, I'm not for Diddy one way or the other. I'm for American law. And there is a presumption of innocence that they're going to have to remove. But I do get the sense, based on my experience, which is more than anybody you've heard from, basically, that most of this was lawfare. That's the new term. It's a violation of the Bill of Rights, and what it is designed to do is to improve the circumstances of people who are implicated in 15 years worth of close scrutiny, surveillance, and recordation in some things that are distasteful. Now, that's what we're dealing with here. So it's like American law is not supposed to favor any one person or class of people over another, but you're looking at it. And I
Right.
think it has a great deal to do with what was anticipated as the outcome of the November 2024 election cycle. So let's just leave it at that for right now. Later time and place, we can get deeper into it. But
I do want to.
this is just something that happens. And by the way, 2 hours worth of trial instructions seems like a lot, but I have charged on a first degree murder case where I've had to read jury instructions for 8, 9, 10 hours after having to draft the doggone things or assemble them. And you have to put them in writing, and you have to put those written instructions in the trial jacket. Now they have a thing where the judge's computer gets activity gets put up on the board so the jury can read it, because I guess they can't read and write anymore and look at a written page in hard copy. But that's 2 hours worth of instructions for how many weeks did we go to trial on this thing? That's like, hey, something's wrong with this picture here. It just doesn't match up.
So, okay. So, okay. Here is, I think this was like the piece of the note. It says possession with intent to distribute simply means that a person possessed a controlled substance with a state of mind or purpose to transfer it to another person. Since no one could read another's mind, the determination as to a person's intent can be inferred from his or her behavior and any other facts and circumstances you find relevant to the question. If a person possessed drugs solely for his personal use rather than for the purpose of distributing them to anyone else, then the person did not intend to distribute the drugs. A small quantity of drugs standing alone is insignificant to prove intent to distribute, but any amount of drugs, however small, can support a finding that a person possessed narcotics with intent to distribute, as long as there is additional evidence of intent to distribute. In this context, knowledge requires the government to prove that the person knew that he possessed narcotics, that his possession was not due to carelessness, negligence, or mistake. If you find that the person did not know that he had narcotics in his possession, or that he did not know that what he possessed was in fact narcotics, then you must find that there was no violation of federal narcotics law. Although the government must prove that the person knew that he possessed narcotics, the government does not have to prove that the person knew the exact nature. What the hell is
You know
that?
what's wrong with that? Here's the problem. Let's say somebody says, Diddy gave me some cocaine on such and such date. Did he? Was there any lab test on the substance in question, the exact substance in question, to prove scientifically that it was coke or a contraband? Or was it talcum powder that somebody just said was white powder or sugar in something else with talcum powder and somebody thought it was coke? You see, the problem is that they went back 15 years and they allowed so much proof of other crimes and hearsay coming into this whole mess that you have a disaster when it comes down to sticking to the law. That's because they tried to push this. Proof of other crimes is only appropriate when it is absolutely necessary to prove that a crime was committed. For example, an orange and black Camaro 2022 model was involved in the armed robbery. Well, there is proof absolute from eyewitnesses, 5 eyewitnesses, that an orange and black Camaro in 2022 was involved in the robbery of this liquor store at 9:38 p.m. on Thursday night. Well, let's supposing that nobody can ID the people in the car, but there was another armed robbery at 11:58 p.m. that same night involving an orange and black Camaro 2022, and 3 people who were witnesses to that one can positively ID the 3 people who were in the Camaro. And on the previous one where they don't have that, there were 3 people in the Camaro. Well, you can introduce proof of the other crimes to show the identity of the people in the Camaro if the circumstances are the same, and let's say several items in the license number were the same. That's proper use of proof of other crimes. But what they have had a habit of doing lately is, instead of using proof of other crimes for that, they've tried to prove that the person had a propensity or habit to prove a crime. But that's not sufficient under American law that somebody is a criminal. You have to prove that the person committed this particular crime on this particular date and time or during this time period. And that's what they're running into here. And it's also a problem that could have been cured by a slight deviation from these instructions to deal with the particularities of this case, which shows to me that perhaps a lot of people involved did not have the breadth of experience to anticipate that weeks down the pike there was going to be this problem.
So just going back real quick to the narcotics distribution, because you also said this. Now, aside from when they raided his home and the day he was arrested in New York City and they searched his hotel room and they found drugs, the pink powder, aside from that, because they tested that because that's what they found in the evidence, the drugs during this trial, when they were questioning the witnesses and people were saying there was this drug, it was that drug, it was that drug, that would technically be hearsay because there was no evidence.
It's an unbased opinion. In other words, this is an illicit drug. How do you know? Give you a classic example. A trial. The problem is they're accusing the defendants of possession of heroin. Heroin, unlike the movies, is not a white powder. It's brown. Heroin is a trademark name that the Hershey Chocolate Company had, and it came from 100+ years ago when they sold heroin legally across the counter in a drugstore. So what happens is the police narc squad bust in. The people in there dealing with the alleged heroin hear it and they flush it. So when the narc gets in there, all he can testify to is he saw a brown substance swirling around the toilet bowl as it was being flushed, and he couldn't dive in there to get a handful to test. So what did we have? Everybody knows what's brown and swirls around in the toilet bowl when it gets flushed. Or did we have a narcotic substance? You see, because none got tested. And even if some got tested, is it the right dope? In other words, who seized the dope? Identify the officer. When did he come in possession of the dope and what are the circumstances? Who did he surrender the alleged dope to? Where did he leave it? What lab did he take it to? Who in the lab took possession of the alleged narcotic and who ran the test? And what did the test show? And then who got the results from there back to where it's getting to, where the jury hears about it? See, all of these things have to go in to lay a proper foundation. And a lot of times that fails.
So, right. If someone getting on the stand saying something, that's not laying a proper foundation based on.
No, it's not, because there's a thing about expert testimony. You have to show by virtue of experience, education, involvement, that this person knows so much about the subject that unlike other witnesses, he or she can state an opinion about it. All right. I had a
An opinion is not a fact.
no, it's not. Sometimes the only way of arriving at the truth is through the testimony of an expert witness who, by dint of his or her particularized knowledge of the subject, is allowed to state an opinion. Now, there's some things that ordinary people can state an opinion about. Everybody in America has been exposed to somebody who was drunk at some point in existence. So when you have such a common experience that's so ubiquitous, it is permitted in most jurisdictions for a layperson to say, he looked drunk to me. But ordinarily, it would take somebody with some expertise to talk about that. Like, what does this mean?
Right. So, and this is the problem that I do have with this case. This is not about Sean Combs and his moral character as far as what he likes to do in his personal time in his bedroom. It is about the facts. And when the prosecutors brought, I think it was one of the people, what do you call those people that arrested him and there was raid in his hotel or whatever? They took the stand, but they only spoke to the current arrest and what they found in a hotel. But the witnesses were talking about those years
Decades ago.
of drugs use decades ago throughout the years of all this drug use. But here's the thing for me is you're talking about drug use, but to me, you all were doing it casually. No one didn't force you. And this was not a drug distribution. It was not a drug cartel that's selling drugs. Do you get what I'm saying here?
Yeah, I get it. In other words, how do you know that's what you had there? Were there
that too. Yeah.
In other words, what are we talking about here? Are we talking about a drug or something else? And see, there's another thing too about this whole bit. The woman that's supposed to be the victim, in the midst of all of this going on, she leaves Diddy allegedly. And what does she do? She takes up for, is it something over a year with a new boyfriend? But she goes back to it. And see, in my experience, there's this thing called sadomasochism, S&M. All right. They make porn with this stuff in there. The guy that invented Wonder Woman, he used to write about it. He's also the person that invented the polygraph test. He talked about the wonders of sadomasochism and dominance and torture and infliction of pain. So sometimes you run into somebody who likes to inflict pain and somebody that likes to receive pain. They hook up and they get a real weird sexual thing going on that they like. So years after the fact, when circumstances change and there's a blame, why did you put up with this? Why did you go along with it? Well, he did this. I was a victim. Well, yeah, but you did this for 10 years and you kept going back and you got an interval in this 10-year period where you were living with somebody else for a whole year, but you left that guy and you went back here. Now you're pregnant with another somebody you married. So what happened? Somebody leaned on you and threatened to prosecute you. So you said, I'll fold. Now you got this complex thing to explain to your new husband about why you were getting your freak on doing what you were doing. It's like I represented many, many pimps and prostitutes in my career. They got the rent paid. You didn't like it, but they were entitled to the due process of law. I had a program to get the prostitutes off of the whole track so they could get away from it. But they kept going back. And I said, why do you keep going back? I got you away from the pimp. I got you a situation where we put money of yours in an escrow account so you would have the financial means, but you went right back. What is going on here? Well, I'm a bad person. I just knew that I deserved this punishment. Well, you're doing it to yourself. But you see, it doesn't look that way when you isolate just the behaviors that are in question without what's going on up there. And the defense in this case did not go to the point of bringing in expert witnesses to talk about this phenomenon of S&M.
I think they should have. They should have brought in their own specialist. Let's swing to the prostitution, the prostitution element, because it is the man, but it is against the law to solicit prostitution.
Yeah, but it's a misdemeanor.
But you said this to me earlier. There was no police officer there to.
That's where I was going.
So go ahead and explain that.
Okay, generally in America, except the new trend over the last couple of decades to allow exceptions in such things as domestic violence, there has been an ironclad rule in American common law and English common law that preceded it for several hundred years that you cannot arrest someone for a misdemeanor that was not committed in a law enforcement official's presence. In other words, you can, if there's a warrant that's been sworn out by someone in front of an independent magistrate who issues a warrant, but if there's no warrant, you do not have a valid arrest unless there's an officer who witnessed the misdemeanor. So when you have a misdemeanor, which is in this case solicitation of prostitution, what winds up happening is it goes absolutely nowhere unless there's a pre-existing warrant for it or that some cop or a law enforcement official witnessed. So where is the witnessing on this thing? And it comes from a 111-year-old statute that is under what's known as the Mann Act. That's what they got R. Kelly on. R. Kelly seems to have had a problem with pedophilia in young girls. And I don't like that personally. But here's what we have is the Mann Act was designed as a historical fact from, as revealed from the legislative history, to get Jack Johnson. Jack Johnson was the first black world heavyweight boxing champion. He had a legitimate white wife. And he and his white wife used to travel around the country with her white girl entourage. So a lot of people 111 years ago objected to this very strenuously. This big, mighty black man traveling, dark-skinned black man traveling around with a white woman. That, oh my God. So what went on is they created the FBI to go and investigate this so they could come up with what became the Mann Act. Now, what the Mann Act says is transporting females across state lines for illicit purposes. One, that's sexually prejudicial because it just deals with females in one sense right there. But that was okay more than a century ago. The other thing is, what is illicit purposes? Well, some places like Tennessee used to call having oral sex with your heterosexual girlfriend or spouse was a natural sex act, which carried 3 to 15 years in the state penitentiary. Believe me, I know about it because I represented some defendants charged with that. The jury freaked out when they found out what it would. Wait, Jesus Christ, you mean what my wife and I do could get us 3 to 15 years in the state penitentiary? Yeah. But anyway, you see, that's an illicit act. And the way it went down is certain states in the United States before World War I did not recognize marriage between the races. So when Jack Johnson and his wife went through one of these states, the U.S. Marshals jumped on board the train accompanied by unarmed FBI agents because they couldn't be armed back then. And they arrested Jack Johnson because that state said that they did not recognize interracial marriage. And what wound up happening was that allowed the fact that he was with this consenting adult woman crossing the state line to be considered an illicit act. And see, they've never cleaned that up. So I think the whole statute is unholy. Now, what wound up happening, to show you about this, Jack Johnson, the target of the Mann Act, which more than 100 years ago was made into law, which is what they got R. Kelly on, which is what they have Diddy on, 5 counts of that. What that is about is, look, who is to say that this is illicit? What is the definition of illicit? And what happened with it, Jack Johnson is the first person convicted. The target of it, you know how much he got for convicting for this? 1 year. He escaped from the penitentiary setup and went to France. And when he came back, because his mother wanted to see him, he tried to sneak back in, got caught. He got more time for the escape than he did for the crime. Look at the Tyler Perry thing, talking about beautiful black or something like that. Look at the series, the popular series, P Valley. Look at all of the glamorization that Hollywood has given to this pimp hoe game for 50 years. They have made it a legitimate practice rather than criminal. So you've got the public thinking this is okay. You've got Hollywood that has propagandized itself into thinking this is okay. So you've got a procurer and a pimp, if you take it that way, here in Diddy, who is trying to ensure his position in Hollywood or the entertainment field. And you're going after him, and what do you hear all the time? Hey man, it's about pimping, man. Pimp your ride, man. You know, like
No, this is why I want to ask you about the prostitution, because just because if I solicit a prostitute and a police officer does not witness me doing it, or is not the undercover police officer perpetrating to be a prostitute, if I'm not caught in the act of soliciting a prostitute, no one cannot come back and say this person paid me for sex, so I want you to press charges.
yeah, kind of sort of like that.
And the prosecutors, technically, they can't say, well, you paid for sex 2 years ago, but you didn't get caught when you did it. But this person said you did do it, so we're going to charge you. That's not how it's supposed to go.
Well, let me put it this way. Here's how it works in practicality. Let's just say this happens and somebody said, hey, everybody, if they approach you, remember you have a Fifth Amendment right to remain silent. Did you buy any from this person? I take my Fifth Amendment rights and I refuse to respond on the grounds it might tend to incriminate me. How about you? Did he offer you sex? I refuse to respond on the grounds it might tend to incriminate me. So the only way they could prove that was for somebody to incriminate themselves, which you cannot compel anyone to do. You have a right to remain silent. If you
And he didn't take the stand, did he?
Yeah. See, this is it, where if everybody is involved, they do that. Like back in the civil rights era, people called it that, a militancy. Somebody used to be doing something and there'd be 8 or 9 people, the police would be, hey, anybody in here heard of the Fifth Amendment, the right to remain silent? Yeah. Well, I choose to remain silent. Well, I choose to remain silent. Did you see it? You know, want to know. Well, you're not getting anything.